So the topic is general, but I want to focus on a specific issue because I think it brings forward the generalities by looking at the specific issue. It's the hosting of Anti-Apartheid Week at the University of Manitoba. And it's my view that the university should not do it, no university should do it, that it should be banned. And that issue raises questions of freedom of speech in a university context. So let me try to argue that proposition. I have written a book, as you've heard, about hate and free speech, where I basically argue that the prohibition of hatred is consistent with human rights generally, including the right to freedom of speech, because incitement to hatred inhibits, it certainly allows free speech for some, but inhibits free speech for others. I mean, obviously I've written a whole book on it, so I'm not going to be able to tell you everything I've got there in a few seconds, but to give you one example, there was a fatwa against Salman Rushdie that was issued by the Ayatollah Khomeini, saying that he should be killed. Now, killing Salman Rushdie in the exercise or acting out that fatwa would certainly be an exercise in free speech of Ayatollah Khomeini, but would certainly not be an exercise in free speech for Salman Rushdie. And on balance, the human rights answer to what you do between the competing rights of Ayatollah Khomeini and Salman Rushdie is protect Salman Rushdie. And so I'm very concerned about incitement to hatred and feel that it should be in some context prohibited. I've also wrote another book called Aftershock Anti-Zionism, Anti-Semitism. As you've heard, I've written a number of books, and that's another one, where I deal specifically with the context of anti-Zionism and its connection to anti-Semitism and the problematic nature of anti-Zionism. Now, what I've learned in dealing with incitement to hatred is that it often comes in coded form, not just anti-Jewish hatred, but all forms of hatred. I've been dealing, for instance, with hatred in Rwanda and the case of Mugesera, where he was eventually ordered deported for crimes against humanity because of a speech that he gave that talked about sending people down the river, and it had all sorts of quoted references that made sense in a Rwandan context, but may be hard to understand elsewhere. I mean, even anti-Semitism as a term, it's now come to mean Jewish hatred, but it didn't start out that way. It was, in fact, invented by a German national, Wilhelm Marr, in the 19th century as an ideology which he espoused opposing Semitism, which he saw as the world Jewish conspiracy, world Jewish control. It was opposing something that didn't exist, but his fantasy of its existence and the Nazi fantasy of its existence led to the Holocaust. And there's something like that with Israel Anti-Apartheid Week. There is no apartheid in Israel. I was very involved in the anti-apartheid movement. In fact, in one of my other books called No More, the Battle Against Human Rights Violations, I've written a whole set of chapters on that, and I've been to South Africa half a dozen times. I mean, there's no resemblance whatsoever between apartheid and what goes on in Israel. Apartheid is basically the denationalization of nationals of a country, the blacks in the case of apartheid, and allocating them to artificially created Bantustans for which they were given nationality by the South Africans, moved to those Bantustans and then not allowed to leave them except with passes or work permits and so on. And Israel in its history has not denationalized even one person by on the basis of their color, their religion, or their ethnic origin. So it's completely wild. But just like there's no Semitism against which anti-Semitism plays off, there's no Israel apartheid against which Israel anti-apartheid plays off, but it is very problematic. It's a coded form of incitement to hatred against the Jewish people. what you had historically was the incitement to hatred against the Jewish people as individuals, as Jewish world conspirators, killing of Christian babies for matzah, and so on. There's a whole bunch of myths that developed around them. Once there was a Jewish state, this anti-Semitism transformed into an attack against the existence of the Jewish state. That a lot of the myths that became identified with the Jewish people transferred to the Jewish state. And just as anti-Semites say Jews should not exist, anti-Zionists say the Jewish state should not exist, denying to the Jewish people the right to self-determination, which exists for every other people. And this anti-Zionism has a whole host of slurs and slanders and incitements associated with it. There's a delegitimization attempt directed, and a demonization attempt directed against the State of Israel as a way of attempting, through words, to argue for the destruction of the State of Israel. And the slur of anti-Israel apartheid or Israel apartheid is part of that panorama of demonization and delegitimization. Now, I say that it is part of incitement to hatred and should be banned, but I also think we have to look at it in a university context. Often, because I deal with universities a lot on this issue, and often what you hear from university is, well, it's in the criminal code. If it's an offense, they should be prosecuted. If it's legal, we can do it. But that, to me, is an abdication of the responsibility of the university. First of all, there's no obligation. There may be an obligation in terms of freedom of speech to say that somebody should be allowed to say something, write something, but there's no obligation in the university to give a forum to everybody. The university is a contained environment. Only some people are students or professors or employees of the university. It's supposed to be a community of scholarship. Rupture the community, you destroy the university. And that's what incitement to hatred does. It disintegrates the community by inciting people against each other. So I would say, and in my book, Bloody Words, I have a whole chapter on this, I would say if you want to remain true to the idea of the university, and I quoted Cardinal Newman, who's now going to sainthood because of his work on an idea of a university. But if you want to remain true, in the book I quote him, but if you want to remain true to the idea of a university, you have to combat against the fragmentation of the university community. You have to keep up the scholarship ambitions of the university, and to do that, you have to stop the fragmentation, the incitement to hatred. And this is not just a theoretical problem. I am not just saying that you allow this and university will disappear. We have seen this happen. I mean, it's a relatively early phenomenon in Canada, these anti-Israel apartheid weeks, but they're much more common in universities. And in Europe, certainly York's got its problems, and in Canada. But what we see is in an atmosphere of hostility, harassment, and intimidation against the Jewish population, to the extent that we see Jewish students staying away from these universities, and in some countries where it's pervasive, a downturn in the Jewish student population. This has become an attack on the Jewish population at universities, and it should be stopped. Now, there are different ways of doing it, but in my view, what the University of Winnipeg has done sets an example, because the anti-Israel apartheid advocates are going everywhere. And this is very common with incitement to hatred, that mostly what they're talking about is nonsense, but they're looking to credible institutions to give them credibility. They very often will look to universities or libraries or places that give them a cachet of respectability. There's a Holocaust denial journal. That's all it does. It writes Holocaust denial articles. It's called the Institute for Historical Review. It pretends to be review rather than denial. It has this disguise of respectability. And So, and what you're mostly getting in universities are people who are not aware of the phenomena. They're not aware of the coding that under the garb under which incitement to hatred could be found, so they think that there may be something there. Well, what the University of Winnipeg has done, and this was Lloyd Axelrod in particular, he says, okay, you can have your Israel Anti-Apartheid Week, but you can't call it Israel Anti-Apartheid Week because that's a foregone conclusion. It's an assumption. Talk about the issue as much as you want, but don't label it with a foregone conclusion. And that, frankly, was my attitude as well. Last year, this past year, there was an Israel Anti-Apartheid Week here. Originally, I was asked to be part of a panel to debate whether there should be an Israel Apartheid Week, which I, of course, would have been quite happy to do and say some of the things I'm saying here. But then what they did is they turned it into an Israel Anti-Apartheid Week in which this debate was ensconced. And I refused to participate in a week or a debate with the label, this is Israel Anti-Apartheid Week. And I think that's what we should be avoiding. I can see my chair is telling me my time is up, and I must say that I've known Arthur Schaefer for a long time, and I know I should not disregard what he says. So my time is up. I think I've more or less made my points. Thank you very much.
Now, how is that working? Can you hear me?
You want to put it back up on the floor?
Maybe. How's that?
Good.
Better? Okay, great. Just need to get my notes. Okay, so thank you very much to the organizers for inviting me to be part of this panel. I have a great deal of respect and admiration for both of my co-panelists, and I'm just really quite honored to be here. In preparing for today, I read the materials that were put on the website, and I hope that you all did, because they were very enlightening. And a question popped into my mind, and it's this. Why is there so much, why is there so little controversy, or perhaps so little relative controversy and concern about human rights regulation of speech in the workplace, in housing, or in access to public services and facilities, and yet it becomes so difficult to deal with when we start to expand into other realms of the public sphere. And by this, I mean that we regulate poison environment harassment regularly through human rights legislation. I'll talk a little bit about that. Now, this is not meant to be a rhetorical question at all. I actually think there are a number of reasons, and I'll talk about that. But I thought that the answers might help us tease out a bit some of the issues that are raised here. And so that's what I want to do with the 10 minutes that I have with you today. And I will just warn you that I'm not giving you any answers at the end. I'm actually just coming up with some more questions. So sorry about that. Now, when I work at the Human Rights Commission, I don't ever advise on hate speech issues because there isn't such a provision in the Human Rights Code. We do have a provision that prohibits what are called discriminatory signs and statements. But this makes up a very small part of the work of the Human Rights Commission. And to my knowledge, at least in the current incarnation, a complaint has never actually gone to a tribunal on that issue. It's always stopped at the commission stage. And this is not unique to Manitoba, and I think others have written about this to a great degree. Sort of anti-hate provisions and this type of provision that we have in Manitoba, the complaints under those provisions make up a very small part of what human rights commissions do and what happens under human rights legislation. But I did often advise on another kind of regulation, I would say, of expression, which were these harassment complaints. And as you will know, harassment is prohibited under human rights legislation. It generally has the same definition. And basically, and there are many forms of harassment, but one kind is often termed poisoned environment harassment, and it will be some type of somewhat persistent comment or conduct based on one of the protected grounds that gives sort of a demeaning message to employees in particular vulnerable groups about themselves and has been said to impinge their dignity. So when that happens in a workplace or in other activities covered by the code, so for example, a housing that's offered to the public, your apartment building, or a service or facility that is offered to the public, the Human Rights Code says that whoever's responsible for that activity, so it's often an employer, could be a business owner, a restaurant owner, or what have you, and it's whoever's involved in the activity that takes place there, so it may not have to be an employee who's engaging in the harassing conduct, it could be somebody else, that they have a responsibility to do something about it. And they have a responsibility that, let's say, the employer to take steps to find out what happened, to put appropriate policies in place to protect people from this type of conduct and comment, to educate those that are involved to the degree it's possible, to make sure that it doesn't happen, and that kind of thing. So, and I would just point out that this type of regulation is not only in human rights legislation. For example, under new workplace health and safety regulations, there is an obligation on many employers to put in place anti-harassment policies. So they can also be responsible under that legislation. Now, and it's important that this type of harassment doesn't have to be focused on a direct victim per se. And what I mean is that you don't have to have comment that is targeting Sarah or Michael per se. What can happen is, just because of the nature of the communications and the comment, it can be giving that message that if you belong to a particular group, you're less welcome in that workplace. You're less valuable. And I'm sure I don't have to give you examples of the kinds of things that do happen in workplaces. Quite often, you think you've seen it all, and then you see something new, and it can be quite shocked by what goes on. But very commonly, it'll be email jokes being sent around, a poster that's put in the lunchroom. It can just be discussion that happens involving employees and so on. So, the fact that we do regulate this type of speech, and it often falls far short of what we might consider hate speech, makes me wonder, why is it so difficult when we start to be expanding into other spheres of public activity, on the internet, for example, that it becomes so much more difficult to regulate it, and both from a practical perspective and a values perspective. And I think a few reasons come to mind to me, but I think you may also have some thoughts. The first is that it's hard to sort of pin responsibility on any person who's responsible entirely for the public sphere. It's not like you can point to an employer or what have you. If anybody, it's the state. If we're talking generally about all of our sort of social relations and interactions, really the only person responsible for that is the state. And what does the state have at its disposal to deal with individuals engaging in this type of speech? They're quite powerful tools, and arguably more powerful than what an employer might have at their behest. The state is powerful. At the same time, and I may be wrong about this, it's a bit of a gut reaction, but it strikes me that the state really has less practical control over what happens in the public realm when compared to an employer. I mean, it's so vast scope of activity that we're talking about. And as we know, it's very difficult to regulate criminal activity, and that's very much bound by the resources that are available to the state. And of course, when we're talking about interactions between individuals and the state, in a democracy, the issue, there is this sort of additional idea that we need to be able to critique our state. We need to be able to speak freely in our interactions in the public sphere, and I think that obviously is why we're all here today. So there's that whole piece. I think also the scope of activity that is covered raises some unique questions. We may say, you know what, it's fine to say to individuals, when you're in the workplace, when you're dealing with your neighbors in a condominium building, when you are at a restaurant or what have you, that you can talk about issues and so on, but you need to do so in a respectful way. You can't use demeaning language or what have you. That's okay, but do we want to say that we can't, that no matter where you go in the public sphere, you have to be careful about what you're saying? And I think that gives rise to this concern about the chilling effect of this type of regulation. I think also it raises the question of, can we really do anything meaningful to regulate this type of speech in such a broad context? And I know that that's something that other writers have talked about, including Richard Moon in his report on Section 13. But at the same time, as I say all that, and here's where I'm telling you I only have questions for you, I don't have answers. And I think this partly goes to some of the comments David was making about what happens in universities. We do seem to recognize that being subjected to this type of communication has an impact on people. And it's an impact that we don't want them to have to be subjected to take part in important activities in our daily lives. And are we any less concerned about that impact when it's on the internet or in some other realm where people are engaging in public relations and social relationships? So that leads me to some of the questions that I have. And I'll end with these. Is it possible to somehow circumscribe additional areas of public activity that we may want to regulate? Because until now, when we have anti-hate provisions, it's really sort of focusing on the entire, as long as you're publicizing the communication in question, that brings you potentially under the scope. And here I don't know what the answer, but are there some kinds of activity on the internet where you need to be more careful than others because they're more likely to expose people to the type of comment that you're making? And on a related note, are there people who are potentially responsible for these spheres of activity that could be made responsible for ensuring that it's a safer environment for all those who want to communicate there? And are there other ways short of regulation or legislation or in addition to it that either the state or these persons responsible for these additional spheres could be undertaking? As I said, an employer doesn't just have responsibility to stop the harassing behavior if they can, but also to do what they can to prevent it, to educate people. And on a related note, is there anything that can be done if what we're concerned about is the impact on members of vulnerable groups when attempting to engage in public life and public discourse? Is there anything else we can do that will address the harm that's caused by hate speech and discriminatory speech to make that a more hospitable environment? So I'll end there. As I said, I only have questions for you. As I said, you may think this is an entirely rhetorical question, and there's a very simple answer to it. And if that's the case, I'd be interested in hearing that as well. And I just think it's a wonderful thing to see everyone here and to have a chance to discuss this issue. Thank you.
Thank you very much. I'm very pleased to be here. I'm very happy that I was invited to be part of this forum on these issues that are timely and important. Everybody hear me back there? Excellent. I want to address questions about the legal regulation of hate speech in Canada, so not specific to university settings, but just how the law in general treats hate speech. In the book that Michael mentioned, The Hateful and the Obscene, I argued that there ought to be virtually no legal regulation of hate speech in this country. I'll explain what I mean by the virtually in a minute, but let me make the case against most of the hate speech legislation that does exist before I do that. Principally, there are many, many ways in which we regulate hate speech. But the principal ways in which hate speech is regulated, just in general terms in the country, is through human rights law on the one hand, criminal law on the other. Sarah mentioned that the Manitoba Code does not regulate speech in general, just speech specific to workplaces, workplace harassment, that sort of thing. But the Canadian Human Rights Act does. Section 13 of the Canadian Human Rights Act prohibits speech, communication that, quote, is likely to expose a person or persons to hatred or contempt. And then it lists a number of protected groups that can be subject to complaints about being the targets of hate speech. I think it's not accidental, I'll guess at this, that the Manitoba Code does not regulate hate speech in general or speech in general. Many of the provincial codes do not. Ontario's doesn't either. It's a rather odd item to find in a Human Rights Act or a Human Rights Code. The principal function of human rights codes is to prohibit and to pursue complaints about discrimination, actual acts of discrimination, especially discrimination in the workplace, in education, access to public services, anything like that. The kind of speech that Section 13 of the Human Rights Act targets doesn't exactly constitute an act of discrimination against anybody. You might think that it encourages discrimination or promotes discrimination or makes it more likely or whatever, but it's not itself a discriminatory act. And so for that reason, questions have arisen, especially over the last 10 years or so, about whether this is an appropriate thing for a Human Rights Act to be doing and or to be regulating, and for a Human Rights Commission, like the Canadian Commission, to be in the business of pursuing. The Human Rights Act and the Human Rights Tribunal are principally concerned nowadays with websites. They fall within federal jurisdiction because they use telephone lines, basically. And so most of the complaints, almost all of the complaints about hate speech that the Human Rights Tribunal has heard over the last few years have been complaints about websites maintained by hate groups, which contain hate messages. No question about the fact that they're hate messages in my mind anyway. But the issue is why the Human Rights Commission's in the business of receiving and acting on complaints about those sites to start with. And these questions came to a head a couple of years ago when the Human Rights Commission asked Richard Moon, who's a professor at the University of Windsor Law School, to prepare a report on specifically on Section 13, the section that regulates hate speech. And what Moon did in the report was basically to argue for the repeal of Section 13. And he drew a nice distinction, I thought, in that report, and one which I'm going to build on here. He said there are two different degrees of hate speech. There's hate speech that's less extreme, and that is speech that stereotypes or defames members of an identifiable group. Says nasty things about them. Stereotypes or defames them. And then there's speech that's more extreme, this is a quote from Moon, that threatens, advocates, or justifies violence against the members of such a group. And what Moon argued in the report was that the less extreme forms of hate speech should be subject to no regulation whatsoever. The best antidote to speech of that sort is just counter speech, education, more speech, argument, not the processes of the law, even human rights law. Whereas with more extreme speech that threatens, advocates, or justifies violence, Moon argued that that is should be properly subject to legal regulation, but in the criminal law, not in human rights law. So his conclusion is there's no hate speech that's properly subject to regulation by human rights law, and the Human Rights Commission and the Human Rights Tribunal should get out of the business of regulating hate speech. This is hate speech that's just broadcast in general. This is not hate speech in specific contexts like workplaces, schools, universities, or whatever. Just hate speech that's broadcast to the world at large. It should get out of the business of regulating that kind of speech. And I argued the same thing in my book. So that takes us to criminal law then. Moon does argue there's a place for criminal law regulating at least the more extreme forms of hate speech. Section 319, subsection 2 of the Criminal Code prohibits the willful promotion of hatred against an identifiable group. This is the section of the Criminal Code that was used against Jim Keegstra back in the 1980s that led to the constitutional challenge against this section that was settled in the Keegstra case in 1990 before the Supreme Court. It's also the section of the Criminal Code that was used more recently against David Ahenekue in Saskatchewan, just next door. the Native leader who made anti-Semitic remarks at a conference, and also to a reporter from the Saskatoon Star-Phoenix. Now, I want to suggest there are problems with Section 319, subsection 2, the hate promotion statute as well. To do that, I want to propose very briefly a test for the validity or the acceptability, legitimacy of a piece of criminal law. The function of criminal law, as I see it, is to prevent harm, to prohibit and prevent harm, especially harm to others, possibly also some harm to yourself, but primarily harm to others. And so it seems reasonable to impose a harm test on any piece of criminal law. The conduct that's targeting, the conduct that it's prohibiting, must be conduct that is harmful to others or at least imposes a substantial risk of harm on others. And my problem with Section 319, the hate promotion section of the Criminal Code, is that I don't think it can pass that harm test. And I'll just give you briefly 2 reasons why. First of all, it talks about promoting hatred, actually intentionally promoting hatred, but the intent requirement doesn't matter too much for us right now. As it's interpreted by the court, promoting hatred doesn't require that any hatred actually result from what you've said. You're promoting hatred if you're saying something that might end up with people hating somebody, but you don't actually have to show that any hatred resulted. So if I stand up before a neo-Nazi rally and say all kinds of inflammatory things about the Jews, but I don't actually succeed in promoting any more hatred than they had already, right? Or if I stand up before some other group and say inflammatory things about the Jews and they just laugh at me, I haven't actually promoted any hatred, but I've still broken the law. Within the terms of the act, I have promoted hatred even though no hatred actually resulted. Secondly, the section talks about promoting hatred. Now, hatred is an emotion, or an attitude, if you like. It's not unlawful to hate people. It's not unlawful to hate any of the identifiable groups that section of the code protects, groups defined on the basis of religion, race, ethnicity, sexual orientation, or whatever. I can hate gays, or Asians, or blacks, or Jews. That's not against the law. It seems odd that it is unlawful to promote something which is not itself unlawful. I think that's an odd use of the criminal law. But my basic complaint about it is that the harm here, the harm that's supposed to be done, is just far too remote and speculative for this to qualify as a legitimate piece of criminal legislation. There's not a sufficiently concrete or direct connection with any harm to others for this to qualify as valid or legitimate law. Now, one remedy here, one possible remedy, is to go back to the distinction that Richard Moon was drawing. What about the extreme forms of speech that threaten, advocate, or justify violence against the members of an identifiable group? Shouldn't they at least be subject to some kind of criminal control, some kind of legal control? And here I agree, and this is where I'm coming back to saying there should be virtually no legal regulation of hate speech in Canada. The problem with the hate promotion law is that it's too vague and too speculatively connected to any actual harm to others. But we have a different notion, not promoting hatred, but incitement to a hate crime that does the job here. The difference between promotion and incitement is that, first of all, incitement is to an act, not to an attitude or an emotion. And you've incited something when you've contributed to causing it to happen, or at least raised the likelihood that it will happen. And now we have a connection with harm or risk of harm that puts us within the legitimate purview of the criminal law. We have a notion of a hate crime, a crime that's motivated, crime of violence against members of an identifiable group that's motivated by a bias against or hatred of those groups. We have the concept of a hate crime. All we need here is the notion of an incitement to a hate crime. that is hate speech that incites hate violence. That falls within a broader category of legal offenses, of instigating or inciting an unlawful act that I think is perfectly legitimate. Now, as it happens, there is another section of the criminal code that does exactly this. I've been talking about section 319, subsection 2, the hate promotion law, but subsection 1 is a hate incitement law. And what it prohibits is inciting hatred against any identifiable group where such incitement is likely to lead to a breach of the peace. In other words, where such incitement is likely to lead to a hate crime. Now, that is sufficiently specific in terms of its connection to an act of violence against or an act of discrimination against the members of the group to pass the harm test and to make it a legitimate subject of legal regulation. But that's the only kind of hate speech that I think can pass that test. So my formula for the legal regulation of hate speech in Canada: repeal Section 13 of the Human Rights Act, repeal Section 319, subsection 2 of the Criminal Code, but maintain and enforce Section 319, subsection 1, the hate incitement law. Thanks very much.